This case has been pending since 2021. There are temporary orders that were heard and signed in district court on April 6th of 2022. There has not been further action in this cause to finalize since that time. At that time, no child or medical support was ordered against the obligor because she was incarcerated. The state is requesting that we review the period since the temporary orders, whether or not there should be any retroactive support ordered for that period or temporary support, whether there should be support moving order, and to make sufficient orders regarding the medical support of the child, my apologies, and as well as for the disclosure of the information of the parties, whether or not that would be in their safety. And we are asking that the court make these orders final today.
All right. So let me hear from Ms. DeLong, who represents Mr. Garza.
Yes, Your Honor. Mila is the child that's subject to the suit. She is 5 years old. She has resided primarily with Mr. Garza since she was 2 weeks old. There was CPS involvement back then. There was criminal involvement back in, I believe it was 2021. Ms. Chappell-Walles who was only supposed to have supervised visitation with the child, had taken the child and took off on a high-speed chase, was charged with felony child endangerment. I don't know what happened to that particular case, but I do know that she was convicted in 6 or 7 different felonies for which she is currently serving time and has been incarcerated all during that time. Mila's doing great. We're asking that the temporary orders, which named Mr. Garza as sole managing conservator, or actually named him and his mom as joint managing conservators. However, his mom, Wendy Ratliff, passed away in 2023. So other than that, we're asking the court to enter a final order that is consistent with the temporary orders, naming Mr. Garza as sole managing conservator, naming Ms. Chappell-Walles as a possessory conservator, not allowing any possession at this time, not requiring her to pay any child support, and not requiring any medical support contribution by her.
All right. Thank you, Ms. DeLong. And Ms. Chappell-Walles.
Yes, ma'am.
Tell me what it is that you would like the court to do.
So to piggyback off of what Ms. DeLong said, I actually had, it wasn't 2 weeks. It was up until it was on and off because it was a lot of confusion and things of that nature going on. So up until she was about like 13 months. So with that being said, it was not 2 weeks, it was 13 months. There was no criminal activity going on in regards to that comment. There were no involvement of any, well, I mean, it was like a visit or two, but there was no involvement of any services or anything as far as Wendy Ratliff, may she rest in peace. The reason why there was involvement was because of her and her side of her family, just wanting to, make sure, in quotations, that Mila was okay. But she always was, everything was fine. In regards to the incarceration, it's not 6 or 7 charges, it's 4. And I just think, I do not mind, the whole, not paying child support and things like that. As far as that goes, I honestly, because as I'm about to get out, and I have everything set in order for Mila, like when I come home, so I have my own, everything's set for her. So, but I know Mario is a good father, and I know that she adores him very, very much so, as I like recently, like short contact with them recently. I have reached out to Mario in like the past 2 weeks. So we have communicated, and but he never brought anything about court. But as far as that goes, I mean, we're on the same page. I just want what's best for Mila as her mom. So if what's best for her is to go ahead and, you know, agree with my child's father, with her father and his attorney, then, you know, whatever for Mila Rosalind, whatever. I just want, you know, her to be good from all angles, however that comes. So.
All right, thank you.
You're welcome.
So we're going to go ahead and put 30 minutes on the clock for each side. I'm going to count Ms. DeLong and Ms. Hobron as a side because y'all seem to be pretty well aligned. And then Ms. Chappell-Walles as the other side. Did you have any witnesses you wanted to call, Ms. Hobron, or you want to defer to Ms. DeLong?
The state would like to defer to Ms. DeLong's case in chief and then make our closing statement based on our requested relief. We don't have any evidence to introduce at this time, but maybe cross-examination.
All right, thank you. Then Ms. DeLong, you may call your first witness.
Yes, Your Honor, I would call Timothy Garza.
All right. Mr. Garza, will you please raise your right hand and be sworn? Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead.
Please state your name.
Oh, my name is Mario Garza.
And you go by Timothy, is that correct?
Yes, ma'am.
Timothy is your middle name?
Yes, ma'am.
Okay. And you are Mila's father, is that correct?
Yes, ma'am.
How old is Mila?
5 years old.
I'm
And
having a hard time understanding Mr. Garza. He seems to be far away from a mic, and so his words aren't clear.
He's 5 years old.
and where do you currently reside?
In Bay City.
Okay. And who do you live with in Bay City?
What did you say?
Sorry.
I'm sorry, I can't, we're having a hard time understanding you, Mr. Garza. He's a little bit garbled. I don't know if that's, if you have a different microphone you could try, or
I'll get closer because my laptop that I was using doesn't have a camera. So I'm on the tablet. But no, I reside in Bay City, Texas, and yes, she's currently 5 years old.
and who do you live with?
My dad.
When we did the temporary orders back in 2022, you and your mom, when you were at LIF, were named as joint managing conservators. Has your mom passed away?
Yes, ma'am.
And she passed away in 2023, is that correct?
Yes, ma'am.
So, tell me about how Mila's doing. Is she in pre-K now?
She's doing good, but no, she's going to kindergarten next year.
Okay. And was she in pre-K last year?
Yes, ma'am. Well, it's kind of pre-K. She did 2 years of Head Start.
She was in Head Start?
Yes, ma'am.
All right. And then she starts kindergarten this fall?
Yes, ma'am. Next month, actually.
Okay. She healthy?
Yes, ma'am.
Is she happy?
Yes, ma'am.
All right. Who else lives at the house with you and your father and Mila?
My grandfather.
So you have backup.
Yes, ma'am.
Okay. When did Mila first come to stay with you primarily?
Primarily, when she first started living with me,
Yes.
I think she was like only. I don't think she was a year old yet.
Okay. And what were the circumstances that led to her staying primarily with you?
I think Raven had got sent to jail, and CPS gave her to me, or they were going to take her to foster care.
Okay, so CPS placed
Yes,
Milo with you? All right. And was there an understanding or a parenting plan that provided that Miss Chappell-Walls' possession would only be supervised?
yes, ma'am. There was a temporary order when we had our CPS case, because we had a CPS case for I think a year, maybe, or a couple months. And they said that temporary orders would be in place for that.
Okay. In 2021, I believe it was Mila primarily in your care?
Yes, ma'am.
And was there an incident in which Miss Chappell-Walles came and took her from you around Christmas time?
Yes, ma'am. We had a mutual person to do a visit with, and she ran out the door with Mila and took off on a car.
All right. And
I didn't understand what you said after ran out the door.
Yes, ma'am.
Was-
She ran out the door and got in her car and took off with my daughter.
all right, so she took off with Mila. Did she have a car seat?
No, ma'am.
Was she going at a high rate of speed?
Yes, ma'am.
Was she subsequently arrested?
Yes, ma'am. Eventually.
And was she placed in the Bexar County Jail?
Yes, ma'am.
All right.
And I'm sorry, when was this and how old was Mila?
Think about maybe, I think turning 2, maybe, or no. I think she was about a year old, somewhere around there.
So it was Christmas of 2021, is that right?
Yes, ma'am. So she'd be about a year old.
Okay. Now, since that time, has Miss Chappell-Walles had any possession of Mila?
No, ma'am.
Since that time, are you aware of whether or not Miss Chappell-Walles has been out of jail or prison during any time?
I think for a brief moment, but other than that, no, ma'am.
Your Honor, I would bring it up here. I would offer Respondent Father's Exhibit 0001, which is the criminal history conviction name search from the Department of Public Safety Criminal Records.
All right. So hang on just a minute. Have you uploaded these to Box?
I have, Your Honor.
Let me pull them up.
This is straight from Box that I'm sharing.
Perfect, thank you. You may continue.
So I'm offering Respondent Father's 0001.
All right, is there any objection to this exhibit?
No, Your Honor.
Is that, excuse me, Judge, is that from their side or my side as well?
So that's being offered by Ms. DeLong, so everybody will be able to refer to it and use it. Will you put it back up again for a moment?
Yes, Your Honor.
So I know you're not able to see it, Ms. Chappell-Walles, but
I heard everything she said. Yes, ma'am.
okay, great. Do you have any objection to this document?
To her document with Mario?
To petitioners, Respondent Father's Exhibit 001.
To anything he just said?
I'm sorry?
to, because I have an objection, but I just want to know if I'm objecting to the right thing. Are you saying?
So right now, let me just stop you. I'm not asking you if you object to anything he said. I'm
Okay.
asking if you object to the introduction into evidence of this criminal history document that is, how many pages long is it, Ms. DeLong?
Like 16, Your Honor.
So do you have an objection to this document, Ms. Chappell-Walles?
Is the document, even though I said I heard everything she said, is the document just my criminal history from the years?
Yes.
Or no? I think I do have it. Yes, I do. Yes.
What is your objection?
I was not, I didn't get incarcerated. I think I do, but like I said, I wasn't notified of any of this, so I'm speaking off of my head, like off my dome. But, I think, like, I know the dates of the criminal, like, of their arrest and things like that are not all accurate.
All right. And you'll have an opportunity to tell me what's inaccurate about it, but the objection is overruled and Respondent Father's Exhibit 1 is admitted. There is a summary on here which we can talk about if Ms. DeLong does not ask her client about it. Go ahead, Ms. DeLong.
Thank you, Your Honor. I'm offering Respondent Father's Exhibit 002, which is the parole review information straight from the Texas Department of Criminal Justice Institutional Division, which states that parole was denied October 29th of 2025, and it states the reasons for the denial. So to offer Exhibit 0002.
All right. Does anybody have any objections to this exhibit?
No, Your Honor.
Ms. Chappell-Walles, do you have any objection to this exhibit?
Yes, ma'am, I do, but you said whenever, it's my turn, then I do though.
Yes, this opportunity is just a chance for you to tell me if you think a document is fabricated or has any thing that is
I'm sorry.
that makes it improper as an exhibit.
Yes, ma'am, it's inaccurate as well.
All right. I'll overrule the objections and RF002 is admitted.
I'm going to pass Mr. Garza.
Yes, ma'am.
All right. That means, Ms. Hoburn, if you have any questions for him, you may ask them now.
No, Your Honor.
All right. So Ms. Chappell-Walles, if you have any questions for him, you can ask them now.
For who?
For Mr. Garza, Timothy Garza. So this isn't your chance to testify yet, but this is your.
No, I don't have any questions.
All right. Thank you.
You're welcome.
All right, Ms. DeLong, you may call your next witness.
Yes, Your Honor, then I would call Ms. Chappell-Walles.
All right. Ms. Chappell-Walles, please raise your right hand so I can swear you in.
Yes, ma'am, it is raised.
All right. Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. All right, Ms. DeLong.
Yes, Ms. Chappell-Walles, you were convicted of aggravated assault on a public servant in 2023 in Matagorda County. Is that correct?
No, ma'am, that's incorrect.
All right, so if that is the information that appears in your criminal history with the Department of Public Safety and also appears on your records at the Texas Department of Criminal Justice, you're saying they're wrong?
Yes, ma'am.
Well, tell me what you believe you've been convicted of.
Okay, as I have my indictment paperwork in front of me from 1700 7th Street, room 307, Bay City, Texas, 77414, Janice L. Hawthorne, District Clerk. It says that I was accused of assault on a peace officer / judge, felony 2, District Court of Matagorda County, Texas, and unauthorized use of a vehicle, harassment of public servant, F3, felony 3, assault on a peace officer / judge, F2, and
I'm
assault
sorry,
on a
we
public
didn't understand.
servant.
Ma'am, you're a little bit fuzzy. The audio is not entirely clear, so we didn't catch what you said after after harassment of a public servant.
Okay. Okay, shall I continue?
Yes, tell me what you said after that.
I said assault on a peace officer / judge, felony 2.
Residents, we can't take your phone.
Can't understand what she just said.
That was some kind of recorded thing from the phone. Go ahead.
I said after harassment on a public servant, felony 3, I said assault on a peace officer / judge, felony 2. And then the last one was assault on a public servant, felony 3. But as if you do not know, when you reach the TDCJ system, the system can change it to aggravated, depending on like the cases you catch in here, or depending on what unit you're at. And I'm at a maximum security unit, so even though the case I'm not, then it's not aggravated. But because I'm at a maximum security unit, it's going to show up in the system as aggravated. But if it was aggravated, I would have to do at least 50% of my time to be able to see parole. And as I've seen parole twice, I'm not aggravated. And then I see them again in September. So I see them yearly. So I'm not aggravated.
Ms. Chappell-Walles, do you recall being arrested October 12th of 2018 in New Braunfels, Texas, on the charge of deadly conduct, a Class A misdemeanor?
And you said, what was the year?
2018.
I was 17 years old. No, ma'am, I do not.
You don't recall that?
No,
And
ma'am, I was 17.
okay, and the DPS records show that you were found guilty and sentenced to 60 days in jail. It was a Class A or B misdemeanor. You were Class A. Do you recall that?
No, ma'am.
Okay. And then in February of 2019, do you recall being arrested by the San Antonio Police Department and being charged with aggravated assault with a deadly weapon?
No, ma'am, I was living in Williamson County at that time.
Okay. So you don't recall that shows up in your DPS records. Do you recall then that the case was reduced down to a terroristic threat and you were convicted?
No, ma'am, I have my criminal history in front of me, and I didn't have any of that paperwork in front of me, ma'am.
All right. In 2020, do you recall being arrested by the Georgetown Police Department and charged with a Class A misdemeanor of assault causes bodily injury? Do you recall that?
Yes, ma'am, I do have that one. Yes, ma'am.
All right. And the victim on that was the paternal grandmother, correct?
No, ma'am, that's not what I have on my paperwork at all.
Okay. Then in 2020, do you recall being charged by the Hutto Police Department with resisting search or arrest, search, or transportation?
Could you repeat that, Ms. DeLong?
Yes. Do you recall in 2020 being arrested by the Hutto Police Department and charged with resisting arrest, search, or transportation?
Yes, ma'am, I do have that one.
All right. And you recall that you were convicted of that offense?
No, ma'am, I just have the indictment for them. The indictment, but it was dismissed. It says on my paperwork.
Okay, so it shows in DPS paperwork that you were convicted and you were sentenced to 10 days in jail, which would likely have been for time served. Do you recall that?
No, ma'am.
All right. In 2021, do you recall being arrested by the Austin Police Department and being charged with second-degree felony robbery?
I remember the situation, but it was not me. No, ma'am. No, I don't. Because
Okay.
I don't have that.
Are you aware that you were convicted of a second-degree felony robbery in 2022 and sentenced to 6 years?
No, ma'am.
So if TDCJ shows that and the Texas Department of Public Safety show that conviction, you're saying they're both wrong?
Yes, ma'am. I have all my paperwork, and I would have it.
All right.
And I
In
don't have it.
2021, December of 23rd of 2021, do you recall being arrested and charged by Bear County with reckless injury to a child? Do you recall that?
No, ma'am. I have evading arrest with detention of a motor vehicle. That's the only one I have.
Do you recall in 2023 being charged with assault on a peace officer in Bay City?
Yes, I have that.
And was it a peace officer or a judge?
Well, Bay City's pretty small, so they had a judge helping out with the transport, so that's why it's peace officer / judge, because the judge was not on duty at the time.
It was actually a judge.
Yes, ma'am.
All right. And you were charged with also harassment of a public servant in December of 2022. Do you recall that?
Yes, ma'am.
All right. And you were sentenced to 8 years in the Texas Department of Criminal Justice. Is that correct?
Yes, ma'am.
And the sentence began June 28th of 2023.
No, ma'am. It began January 8th of 2023. At least that's what the systems show in here.
Oh, all right. So you had been in custody since January of 2023 before you were convicted in June, correct?
Yes, ma'am. I did sit that, though, and wait for court. So, but I got all my back time, so I think it's just off. Like it shows in one place and not the other.
And then in 2023, you were also charged with unauthorized use of a motor vehicle, and that was in Bay City, correct?
Yes, ma'am.
And you were sentenced to 24 months on that one, correct?
No, I was sentenced to 6 months state jail.
In 2023, also, you were convicted of assault on a public servant in Bay City and sentenced to 8 years. Do you recall that?
Ms.
Yes,
DeLong?
ma'am.
Mr. Long, we didn't hear what year or what date you just said.
I'm sorry. In 2023, the actual conviction date was June 28th of 2023. I assume you've been in jail since January. On that case, that was another assault on a public servant, and you were sentenced to 8 years. Is that correct?
Yes, ma'am, due to an officer putting her hands on me, and I asked for the state rangers to be called in, and the state took over because that happened in the county.
And then again in 2023, June of 2023, you were arrested and charged again with assault with a public servant. Do you recall that?
I recall the situation, but it's just ongoing charges. I was never, I was in county at the time, so I wasn't rearrested. I was just there. They were
And you were
waiting to,
and you were sentenced to 8 years on that case, correct?
yes, ma'am.
Do you believe that Mr. Garza is taking good care of Mila?
Oh, absolutely. Yes, with a smile on my face, I do.
Okay. And you believe that it is in Mila's best interest then to remain in the primary care custody and control of Mr. Garza, correct?
I'm sorry, can you repeat that? You kind of went out, Mr. Long.
Yes. You agree that at this point in time, it is in Mila's best interest for her to remain in the primary care custody and control of Mr. Garza, correct?
Yes, yes, ma'am. At this point in time, yes, due to I'm still incarcerated. Yes, I do, absolutely.
And you believe that upon your release from custody, that you and Mr. Garza will be able to talk to one another regarding Mila.
You said, do I believe upon my release that we'll be able to talk to each other?
Yes.
And, oh, we already have. We've talked about it. But yes, 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 ma'am.
Do you intend to obtain any counseling or treatment upon your release from incarceration?
In regards to Mila?
In regards to you being a good, stable parent for Mila?
Yes, ma'am.
And
Absolutely.
what counseling or treatment will you be seeking upon your release from custody?
I wouldn't say it's necessarily just upon my release because it has been since I've been incarcerated because they allow you to do those things while you're incarcerated. But as far as upon my release, I have a very strong family friend, and we already have a person aligned. We already have somebody who she's been knowing for years, ready to, yes, to start with me and twice a week, Mondays and Fridays.
Pass witness.
Is that person a licensed psychotherapist or?
Yes, ma'am. Mm-hmm. Yes, ma'am, she is.
Thank you. Do you have
You're
any
welcome.
questions for this witness, Ms. Obrin?
When is your expected release date?
Well, since I've made parole twice, and I'm not aggravated, I see them every year. Since I've made parole twice, since I've seen parole twice, I'm sorry, I have made parole, but things in the prison have transpired, and I've lost parole. That's why I say the records are inaccurate, because I've actually made it twice, and lost it twice. So I see them again in September, so they'll see me, interview me, the whole process, all those things. And then they'll decide from there, hey, with you being aligned to, these things, what have you, because you have to be like a stat line 1 and a line 2 to go home, and I'm a line 2. So with those things being said, it depends, honestly. I can't really answer that. I can just give you that, because they can say, hey, well, you've made parole, but, we want you to do a pre-release program for 3 months or 3 to 6 months, and those things before. So it
Okay.
really just depends.
If you have to serve out your entire term, when would that release date be?
Well, because of the 6 and the 8 ran concurrent, they'll make me, yes, but the 8's not there, actually. It's not there. That's another thing that's inaccurate. The 8's not there. So 2028, June 7th, 2028.
Okay. And you said you're working with a therapist while you're incarcerated?
No, ma'am. I said that I have a really good family friend, Ashley Wright, and she knows a lot of great people, and she's already looked into getting me counseling, and a lady has already agreed Monday and Fridays.
Is that going to begin while you're incarcerated or after your release?
We're trying to, and we're right now in the process of trying to, but the warden of the unit is kind of not aligning with what we're trying to. So we're reached out to Region 6 and, higher Huntsville and things like, we are trying to do that so that it will be easier and kind of we're already in the flow of things by the time I get released. But right now it's not looking too good, honestly.
Have you received psychological counseling or treatment or testing before?
As far as for my child?
No, for you. Have you been tested or reviewed by a psychologist or a therapist or any sort of psychological professional?
No, ma'am.
Have you sought treatment before and weren't able to receive it? Or you are just now, this is the first time you're going to be looking for a counselor?
I have, yeah, I've sought through the same family friend, Ashley, and another family friend. She's dead now. But yeah, I have before. It didn't really kind of play out the way it should have. But so now would be.
Sorry, I didn't
But
understand.
we've been at it for years. I mean, not for years. We've been at it since 2024. Like trying, and then I've got a unit transferred to this unit, so we have to align with this warden. But we've been trying since 2024.
To get psychiatric treatment for you?
To get counseling in regards to, the trauma of TDCJ and just, the trauma of my life and, just, me having to go into the world and be Mila's, and be a great mom and pursue and flourish and be successful, all those things. We've been trying since, to get as far as like, scheduled treatments since I'm incarcerated in TDCJ since 2024.
Have you ever had an issue with substance abuse, maybe alcohol or another drug?
No, ma'am.
Okay. Are you able to do telephonic visits with the child in jail?
Yes, I can, but we just have to set it up. Like I've been shut down. But yes, I can actually.
What do you mean you've been shut down?
Like, as far as, I think I went about it the wrong way though. I think we, as in like my support system, went about it the wrong way. And I don't think I've ever notified Mario. I think I tried to do it like without him knowing, so that like when it was set up, it was kind of like, hey, this, But as far as like me trying as like me and being her mom, yes, I have. I just think I went about it the wrong way.
So are you requesting the court, while you're incarcerated, are you requesting that the court order electronic visitation with your child?
Yes.
Okay. And you're asking that the father coordinate on his end to receive calls from jail or to initiate. Do you receive calls to the jail or you're trying to call out tomorrow?
Okay, so in regards to that, because, okay, I don't know if I can say this, but I have a whole lawsuit going on, so I don't know how they would go about that, because of who the lawsuit's on and things like that. They could restrict it or they could say, hey, no. But, like, I have a visit on Saturday, so, like, them coming up here and driving up here, at the times, or if that's not applicable for them at that moment, it's like, okay, well then we have this, plan B.
Okay. So if there was ordered supervised visitation at the jail, because that's where you are, that would be
Right.
something that Mario would have to initiate bringing them there?
Yes, ma'am, him, or with the help of his father, or his grandfather, his granddad.
What are the visiting hours that he would be able to do that?
Let me, Visitation hours, or what's visitation hours on Saturday? 8 to what? 8 to 5, Saturday and Sundays.
Okay. And if
As
somebody
def-
if somebody comes and asks for you, is there any restrictions or any reason why they wouldn't be permitted to visit with you on Saturdays?
No, ma'am. No, ma'am, we don't get visitation restrictions.
Okay. And for physical visitation, how frequently would you request the court to order him to bring your child to jail?
Well, I just want it to be, like, I don't want to try to ask for something and then it's like, well, I can't do that, or, work or this, and things like that. But as far as me and what I would like, I mean, me and what I would like is every weekend. But, that may not be, okay for him and his schedule. Do you see what I'm saying?
And then when you have visits on Saturdays, do you have a time limitation of how long you can visit with your visitors?
Yes, ma'am. 2 hours across the board.
Okay. So that it's 2 hours for whoever you meet with.
Yes, but video visits are 1 hour. But where I'm at, I'm in SEG. So, yes, we don't get video visits in SEG across the board. So you have to come up here and,
Okay. And how long, if you were getting visits with your child, how long would you request those visits to be that in your as the mother, in your opinion, for the best interest of the child, how long do you think those visits need to be?
the whole 2 hours.
Okay. And then okay, so just to sum up where we are so far, on Saturdays you have visitation, and any time during the visitation window that goes till 5 p.m. you would like to see your child for 2 hours. So you don't want to see any other visitors, just your child those full 2 hours.
No, yes, but Mario, like, if he, or if she needs, or he, just him and her.
Okay. And you believe that the child will be able to handle 2 hours visiting with you in the jail?
If not, yes, I assume so. Yes.
But if the judge ordered something like, as long as the child can tolerate the visit in Mario's discretion, would you be agreeable to something like that to allow him to take the
Yes,
child
ma'am.
and end the visit?
Absolutely, yes, ma'am. Not too much pressure, for sure.
Okay. And then for phone calls, are you allowed to use the phone every day?
Right now, because I'm in Ag Seg, because of this huge lawsuit. I'm actually D5, but I have a huge lawsuit going on, so the warden doesn't want me on her unit, so she has me in Seg. So, in regards to that, whatever the judge orders, they're going to have to go by regardless. So they can tell me, like right now, it's a level system. Am I wrong? Like, say if the judge orders something, I'm sorry, I'm asking the law library lady a
Well,
question.
it's okay. You don't have to answer that question. We'll figure it out. The reporter's competent to figure that out. But assuming that, so currently you don't have access to the cell phone and you would need a court order, or you do have access to the phone?
We would need a court order.
Okay, so currently you have no permission for calls.
No, ma'am, because of my level.
Okay. All right. And if the court decided to order phone calls, would it have to be you initiating the call to Mario, or would Mario have to call the jail?
To make sure that all goes well, he would have to call. But it can really go either way. But some rank are lazy. You have sergeants that are lazy and things like that, and the warden's not here every day. Neither is the assistant warden. So I can call out, but it may not go like, they may be like, oh well, he didn't answer, da da da. But if he called, it's like, okay, he's calling in So we need to make sure she's out her cell so that she can be present, you know.
Okay, but there's a procedure for you to be released from your cell, get on the phone. So provided the court orders it and the jail, abides by that court order in the best effort to make sure that you're available to be using the phone and calling out, you would, if you get phone privileges, you will be able to call out tomorrow. And it would be then on him to make sure he's available to answer the phone during a period of time.
Yes, ma'am. I'm trying to put my words in the right order. I'm sorry. I'm not on phone restriction, but even if I were to be on phone restriction, this is a whole different matter. Phone restriction is if you have your tablet and you're trying to call out using Securus, but it would suspend the account because you're on OTS phone restriction. But since this is a whole different matter, and which would come with a court order, they can't say no. They can get in trouble.
Okay. So
let me just stop you, Ms. Hobron.
Yeah.
I know you all announced for 3 hours for this hearing, but you told me you could get it done in an hour, and we do have 2 cases stacked up behind this. And
Your
y'all
Honor, yes, I'm at the close of my questioning of this witness as well.
we are way over the 30 minutes you asked for.
My apologies, Your Honor.
All right, let's finish up.
All right, I'll pass this witness.
Thank you. So at this time, Ms. Chappell-Walles, obviously you don't have a lawyer to ask you questions, so you're permitted to testify on your own and tell us anything you think I need to know in order to give you what you're asking me to do.
Okay, well, with me knowing that, Mario is a great father as he is, and, what they're asking for as far as, what you should sign off on today and things like that. I agree wholeheartedly upon my release, but I will ask for you to order scheduled visits for her to come up here. I'm also going to ask for set phone call times as far as what's well and applicable for Mario, and then with school coming up and things like that. But as far as her care and her medical care and things like that, that's I agree with them as far as that, like Mario wholeheartedly for sure. But yeah, I am asking if you can, see that, with me being incarcerated and all those things and everything that's happening right now in the moment, in the present moment, that if you can see that I get more time and, to, see my baby, learn my baby more and more. I've missed out on a few years, so. As you know, the times, Saturday, Sunday, 8 to 5, and then we can come to an agreement as far as like phone call times and things like that. And that's all I have to say.
All right, thank you. Ms. DeLong, do you have any additional witnesses you'd like to call, or do you have any follow-up questions?
I have a follow-up question for Ms. Chappell-Walles. Ms. Chappell-Walles, you are currently at the Patrick O'Daniel unit, is that correct?
Yes, ma'am, also known as Mountain View.
And that is located in Gatesville, Texas, is that correct?
Yes, ma'am, Gatesville, Texas, like right outside of Austin.
And you understand that Mr. Garza and Mila are living in Bay City, Texas, correct?
Yes, ma'am, which is like 3.5 hours from Austin.
It's according to Google Maps, a 4-hour drive. So you're saying that you think it would be in Mila's best interest to drive 4 hours to come see you and then 4 hours back again after a 2-hour visit. So basically 10 hours for a 5-year-old.
Yes, ma'am. It would, when you put it like that, at least once a month. Yes, ma'am.
And you think that would be in Mila's best interest?
As far as her, and as far as me, and as far as her getting to know mommy more, yes, I do. I feel like it is.
That's witness.
No further questions, Your Honor.
All right. So do you have any additional testimony, Ms. DeLong?
I don't. I rest.
Ms.
The state
You
also
have-
rests.
All right. Ms. Chappell-Walles, do you have any other testimony you want to give or evidence you want to introduce?
No, I think I've said it pretty much. Mario's a great dad. No, you know, I miss my baby. I'm ready to come home, but in the time until I do, I would like to, you know, get to, if it's, you know, permitted, get to see and talk to her more with everything that's going on.
All right. Thank you.
Thank
Miss,
you.
so the evidence now is closed. Let me ask, Ms. DeLong, did you want to make a short closing statement?
Yes, Your Honor. I would just say that Ms. Chappell-Walls' date of completion of her sentence is June 7th of 2031. She was recently up for parole. Parole was denied based on the nature of the offenses with which she has been convicted. And there are several of them involving violence. I'm not hearing Ms. Chappell-Walls giving any particular justification, excuse, or explanation for her commission of these offenses. It just seems more matter of fact. We're just asking that the temporary orders that would require Ms. Chappell-Walls to have possession be that she have no possession for the time being. Now, upon her release, absolutely, Mr. Garza has already allowed communication between Mila and Ms. Chappell-Walls. He has communicated with her through an app that is available to Ms. Chappell-Walls, and he's done that with no court order requiring it, and he will continue to do that and do whatever is in Mila's best interest. But to require Mr. Garza to drive a 5-year-old 4 hours to get to a prison setting where she's never been, spend 2 hours and then 4 hours back, even once a month, to me seems not appropriate. Ms. Chappell-Wall says she's going to get out soon. I don't know if that's true or not true. It may be she's not out until 2031. But upon her release, she and Mr. Garza can certainly modify the order by agreement. Ms. Chappell-Wall's right, and the order we're requesting would give her supervised visitation upon her release. And the supervised visitation would be occurring at a location within, let's say, 30 miles of her current residence. And that it would be at Ms. Chappell-Wall's cost and expense. Once she's done some of those supervised visits with a therapeutic supervisor, then they could agree to move on to a more expanded possession schedule. But right now, there's no evidence that would be in Mila's best interest. I'm not saying it wouldn't be sometime in the future, but as I tell my clients, there is no final order when it comes to a child who's under the age of 18, because these orders are subject to modification until that time. Anyway, so that's what we're requesting, Your Honor. We're requesting supervised visitation for the mom, somewhere near the child's residence, no child support, no medical support. And then once she's released, I'm sure the Attorney General will want her to start paying child support and medical support. And at that point in time, perhaps a modification would be appropriate regarding possession, but not now. Thank you, Your Honor.
All right. Thank you. Ms. Hobron, would you like to make a closing statement?
Based on the evidence that we've heard, I do not believe that retroactive child or medical support would be appropriate in this case. It appears that the obligor has been incarcerated for or in some other way not employed and getting income during the period of time since the temporary orders. We are also requesting that no child support or medical support be ordered at this time since she will be incarcerated for at least some time now. So that will have to be modified in the future. For the visitation and possession and access, the state would just request in the interest of policy that we work with today's fact pattern and consider that a modification may be more appropriate on her release for the court to have an opportunity at that time, since it could be 5 years from now, to determine whether or not that would be in the safest interest of the parties as well as the child, since there has been a history of domestic violence in this case. It is the state's position that all of the orders that we pursue are not only in the best interest of the child, but also attempt to ensure the safety of the parties. The evidence suggests that maybe if a step up, or a supervised schedule proposed today, that things might happen between now and when the parties would attempt to do that, that may not necessarily be safe for either parent or the child. So that would be the only state's suggestion or request based on our policy, but we have no objection to the request of the obligee parent in what he's willing to do for the child if he believes that's in the best interest.
All right, thank you. And Ms. Chappell-Walles, do you have anything you want to say?
Yes, ma'am. To Ms. DeLong's statement, as I haven't gave any reason or explanation or on why all those things happened and has transpired. I'm a human being just like anyone else, and I have made plethora of mistakes, more so than others, and more so when I, when I had Mila. So in regards to that, I'm no better than anyone. No one's better than me. I'm incarcerated. That's the only down part about it. But I would do anything for my child, and I love her so very much, and I want what's in her best interest, whatever her heart desires. But I also want her to know Mommy. And I know that it says 8 years and 2031 and all those things, but I know what I have on my side, and it says 2028. So, that's what I'm going to go by unless things change or I hear different. And it's from Huntsville, the people that release you. And in regards to the, driving up here in the 4 hours and things of that nature, I do see where Ms. DeLong is coming from as far as, hey, she's about to be 6 October 2nd. Right now she's 5. She's going to start school. Like, hey, what if they can't do that, or what if they can't? And I was always taught there's no can't, you try, especially when it comes to a child. So, but I don't want it to be any pressure for Mario. I want him to feel comfortable. I want Mila to feel comfortable and things like that. But I also want to get to know my child more. I also want her to know that Mommy loves her and that, Mario tells me all the time through JPays with Securus, hey, Mila's asking this. Hey, Mila wants to know this. Hey, it's hard for me. I need your help in these things. But, there's only so much both of us can do from our ends. He tells me one thing, I can't really respond back because I don't have a tablet, so I have to find a way to respond back, whether it's, hey, can you send a text for me? Or, hey, things like that. Hey, Ashley, can you text Mario? Which most of the time we go through her. So, in regards to that, or, hey, can you call and tell Mario this? Or I write, to the house and things like that. So, if there is no visit because of the time and the distance and things of that nature, I would like that at least, once a month. But if not, then a court order for phone calls because that's easy. Everyone has a phone. Everyone can talk, just like you can get on TikTok and Instagram. You can call, and things like that. I don't want to put any pressure on Mila. I don't want to put any pressure on Mario. I just, we can all work together and figure something out. There shouldn't be no, oh, we'll wait until she gets out because wait until I get out, but my child doesn't know mommy. My child only knows what she's been told about mommy, which is all good things. But, if there can be time implemented into, hey, we can make that once a month drive. It's okay, whatever, gas, what have you. We want Mila to see mommy, or hey, we may not be able to do that, especially because school. Hey, let's go ahead and do these calls, So that's how I see it. So I've made mistakes. This is what it's come to, and we can go from there. I want to talk to my baby, and I want to see my baby more, for sure.
When was the last time you saw her?
Oh, since the incident where the high-speed chase, San Antonio, years.
And I think was that 21 in 2021?
Yes, ma'am. Yes, ma'am. Yes, ma'am. I could have seen her because I was in Bay City and things like that, but I didn't want to. I was in Bay City, right down the street, literally, we did pass. I did see Mario. He did see me, but there wasn't no, me trying to, run over there. I felt like, I had already caused so much, Bay City small, I see you, you see me, Dollar General, H-E-B, things like that. But I'm not going to do anything to jeopardize. You know what I'm saying?
All right, ma'am. When was the last time you talked to her?
Oh,
Was it more recently
on
than?
her, no, ma'am. It was on her birthday in 2024. I called, sang her happy birthday, talked to Mario, or I would call and talk to him, but she would be she would be gone, or she would be with his stepmom, or, she wouldn't be there, so I would talk to him, and we would talk about, co-parenting and our relationship, and, as far as stuff like that, and, how we're going to go about, co-parenting when I get out, and things like that, and he would ask about my classes and my parenting class, stuff like that, but it was for her birthday.
Thank you. Mr. Garza, let me ask you a couple of questions.
Yes.
So you know your child better than any of the rest of us.
Yes.
And so I want to know your thoughts about, let's talk about a request for regular phone calls between.
Yes, I would be fine with the regular phone calls and the virtual visit, but the driving up there 10 hours or the 8 hours driving back and forth, that's going to be really hard to swing. Just because we would probably have to get a hotel and stay the night. That would be too much driving for one day. And
All
then-
right. So I'm asking you about the phone calls. So what is your thought about, wait for me to finish the question, please. What is your thought about whether it's in your daughter's best interest to have regular phone calls with her mother?
I think that would be fine. I think she would really like that, just to get to know her mother and everything.
So how often do you think that would be good for your daughter, and for how long at a time?
I say about maybe 2-3 times a week, maybe.
I'm sorry, I didn't hear that. 2 or
Maybe
3 times a week, did you say?
Yes, ma'am. Just because she has school and stuff, other stuff to do.
And for how long at a time?
And however much time she can call for, like the 30 minutes or an hour or however much time.
What I know a lot of kids have a shorter attention span than that. So I'm just wondering how long you think a phone call could keep your daughter's attention right now.
Say about maybe 20 minutes. maybe 20 to 30.
All right, thank you. All right, does anybody else have anything to say?
No, Your Honor.
No, Your Honor.
All right, so I am going to follow the recommendation of pretty much everyone and not order child support or medical support from Ms. Chappell-Walles, either retroactive or current. I do think that when she is released, after, let's say, 6 months after she's released, she should be required to start paying guideline child support. You'll have to tell me, Ms. Hobron, if that's something that we could draft an order to make happen.
That
No.
would no. The issue would be that it requires knowledge of the income that she's going to have, and for all we know, she's not going to be employed or able to get employment because of her history. So anything that we ordered could potentially be not enforceable because it wasn't based on evidence. It would be speculative at this point. When she is released, though, she can apply. We would not be able to do anything to assist her with the visitation or possession, but she can apply for Attorney General services on her release for modification, and we can assist her with our NCP Choices program and potentially getting work, as well as getting her obligations adjusted and getting her back on track so that, you know, she's providing for the child. But
All
at this
right.
time, the evidence would suggest that we can't order it into the future like that. We wouldn't be able to enter it in our system.
All right, thank you. So no child support or medical support, either retroactive or current. The court's preference would be that after a period of time, say 6 to 12 months after she's released, that she pay guideline child support. I also think that after she's released, that it would be appropriate to look at whether it's in the child's best interest to have supervised visits with her mother. So I would want to encourage Ms. Chappell-Walles to go to the Attorney General's office and get that help that Ms. Hobron just mentioned on
Yes,
how to
ma'am.
get a revised order once you're released. All right, but in the meantime, the father, that is Mr. Garza, will continue to be, well, he's the sole managing conservator. He will continue to be the primary parent, which means that he will make all the various decisions on education, on healthcare, on psychiatric and psychological care, and the like. And that Ms. Chappell-Walles is the possessory conservator without any specific order on visits or contact. That said, Mr. Garza, I want to encourage you to find a way to set up regular phone calls between your daughter and her mother. I do think it's in her best interest that she get to know her mother. And obviously she's gone almost 6 years with little to no knowledge of her mother, and that's not ideal. I do think by all accounts, you're taking really good care of her. I don't have any doubts about that. I do think if you can set up even once a week, 20-minute phone calls between your daughter and her mother, that would be wonderful. But I'm not going to order it because I don't know what the prison will allow, and I don't know after V starts, whether you decide that this is in her best interest, and if you think the frequency is too much or too little, you're in a position to tell what's in your daughter's best interest. So those are my rulings. Anybody, did I miss anything? Mr. Long?
Your Honor, this is Chappell-Walles. Can I tell you something, please?
Just a minute. Let me just ask Ms. Hoburn and Ms.
I have some clarifications that I need and maybe some recommendations to achieve what we're trying to do with your orders. For Dad, he's going to be named sole managing conservator. My understand would be without the requirement to confer with Mom or a geographic restriction. In our cases, typically there's enough evidence here for a finding of family violence, in which case the presumption that Mom should be ordered, to be a conservator, I believe, has been rebutted. She's not capable of doing very much. Typically in our orders, what we make is the finding that it has been rebutted so that she is named as a parent, but not a conservator, and she has the right to receive information about the child, both from the conservator and other parties, but that would be her limited right until further orders of the court. And that would allow the father to make all decisions because he's not going to be able to have access to mother in order to even confer to do any of that while she's incarcerated. For visitation, I believe that if there is a finding of family violence, there would still be a finding that it would not harm the child to have supervised telephonic visits with her, and that it would be enforceable to order that Dad make efforts to initiate a call of 20 minutes once a week, if in his discretion it's in the best interest of the child. Now, including that language gets a little trickier with enforcement. So I would defer to Miss Long if she has some DeLong if she has some problems with that language. But I believe that one of the ways to do that is to put in the order that Dad is supposed to try to do this once a week for 20 minutes, but if he's unable to get through to her at the jail or she's not available, that he's met his duty and she is not entitled to make up time. So that way it's enforceable. He has the duty to consistently try every week to call the jail, to initiate a call with the child for that time. But if there's something outside of his control that prohibits him or the mother from coming to the phone, that is not going to be a violation of the court's orders by either party for not participating in that visit. But based on this limitation, I don't believe we'd be able to kind of use language for makeup time that wouldn't enforcement of the order very confusing. But those would be my recommendations and understanding. The other issues that the state would have is we would ask for court costs that we typically ask for in our petitions to be waived by the court since she is incarcerated and unable to pay. We would also ask for some orders on whether or not it is safe for the parties to release their information to each other as far as their residence address, their email and phone number. Based on the history, it sounds like they're communicating well and they have respect for each other well. It's going okay now. But based on the level of the issues that they've had, the state would recommend that perhaps for the moment, since there's not any sort of physical visitation at the residence or need for that the residential address of Dad and the child be protected for now until further orders of the court, and the parties that he only be required to provide the email and phone number to Mom so that she has, if she regains access to her iPad or ability to email, then that way, if she has the ability to start calling herself or emailing herself, I know the child's little, but they'll get older and they probably know how to technology. So that way she'll have a way to contact him as well as the child's. So I believe that would be an enforceable order that we could do here to accomplish the essence. And for the recommendations as far as when to review guideline support, I believe you said 3 months after release, as well as you would like the court to review 3 months the visitation schedule after her release. I think the most appropriate way that we could speak to the future as it were, in the order would be to make findings, that there is a finding that it would be in the best interest of the child for the court to review the support obligations as well as the visitation orders and conservatorship orders at least like 3 months bound. So that way it would be a finding that we believe that would still be in the best interest of the child. And I think in that regard, it would address this finding of family violence. If we include it, future judges might presuppose that it would be dangerous to everybody. But I believe if we make a finding that it is a good idea to look and reconsider that the release of jail, of her from jail would be a substantial reason for modification and in the best interest of the child to consider doing something different, I think that would meet our goals in the order.
All right. Do you have any objection to anything that she just suggested, Ms. DeLong?
I would like to say, Your Honor, that the idea that Mr. Garza could just pick up a phone and call her in prison is not realistic. That just can't happen. I know that. I've done criminal law for 37 years. That just doesn't happen. Now, they have been communicating through an app that is available to Miss Chappell-Walles, and in any way that Mr. Garza can communicate with her, he's going to allow that. He's going to do that. So I agree with the court's assessment that it shouldn't be ordered. Mr. Garza's been doing it all on his own. No court order, no push, no budge to do that. He's just doing it. So I think that takes care of that. I think that we're fine with her being named as a possessory conservator. We're not trying to bump out her relationship with the child. I don't think she just needs to be named as a parent. Maybe something that makes it easier for the state, but we're asking that she be named as possessory conservator because ultimately she is going to have visitation. Obviously, we're going to have a finding in there that she is presently incarcerated in the Patrick O'Daniels unit because that's going to be in our order. And so if she's out, that's obviously a change of circumstances. I don't think we have to relate that specifically in the order. So that's my thinking.
All right. So at this time, I am going to make
I'm sorry. Can I tell you something?
briefly, very briefly, because we're way over time.
Okay, I've heard, I agree with both of them, but I agree with the other lady, not Ms. DeLong. The reason why you would have to make, which, overall you wouldn't need to make a court order, but the reason why you would have to is because, say, if Mario calls up here, like any other time we could talk on secures, right? But at the time I don't have a tablet. So that's out the park. So you would have to make a court order, Your Honor, because it would go through, you would make the court, that's the only way I'm going to be able to get to talk to her, of where I'm at, where I'm secluded at, where they have me housed. Like, they're not going to, if Mario was to call up here and be like, hey, I want to talk to offender Chappell-Walles, I'm supposed to call because we had court and this is what was said, they're going to be like, they're going to hang up on him. Or they're going to transfer him in the warden secretary, and the warden secretary is going to tell him, hey, if you don't have a court order and it hasn't been approved from Huntsville, like, we don't care what you're saying. Click and hang up, which is unfortunate. So I agree with both of them, but the only reason why I do not agree with Mr. Long on why we should have a court order is because if he calls up here without a court order and there's no email sent to Huntsville or there's no email, because you would have to make the court order, send it to Access to Court Huntsville. They would approve it automatically. Then the warden secretary and the wardens would get an email, hey, Chappell-Walles needs that her child's father is supposed to call through on these days and times, what have you. And then they would lay me in, which is proper protocol, and then the sergeant and then will pull me out weekly for the calls. But if there's no court order, Your Honor, they're not going to pull me out at all, and I'm not going to talk to my lawyer.
I understand. So I am inclined to grant the request that Ms. Hobron made as modified by Ms. DeLong, but I'm also inclined to include a specific day and time for a weekly phone call of up to 20 minutes between the child and her mother. And it sounds like that does need to be in the order. I'm going to ask that you all coordinate on what date and time is a good day and time for the child. You know, maybe it's Sunday evenings at 6 p.m., but I don't want to set those times because if it turns out that they're at bedtime or dinner time or whatever, then that's not going to work. But I also, if you need our help to coordinate with the jail to find out what times they say would work best for them, for her to have the phone call, just let Miss Fatima know. She's the one who sent you the email with the Zoom information today. So, y'all, Ms. DeLong, can you work with Ms. Hobron to draft the order?
Yes, Your Honor, I'd already drafted an order, which I had already submitted to the Attorney General. One of the Assistant Attorney Generals responded that he was in agreement and approved it, but we would do it after court. Ms. Hobron's position is different, and that's fine. We'll work together. I'll get the order drafted and get it to her.
Perfect. Thank you. You think you can get that to me in the next couple of weeks?
Yes, Your Honor.
All right.
Yeah, sure. And my only concern would be the two of us are going to have difficulty conferring with the mother about what the best time and date would be while doing this order. But if she's in agreement that she trusts dad to make that decision and we can get that on the record that she waives her right to participate in that one negotiation, then I think we can go ahead and proceed to getting that final order together based on just the conversations between me and Ms. DeLong in consultation with her client.
All right. Let me just ask you while we have you here, Ms. Chappell-Walles, if you know that there is a day and time when it would be, when you think that the prison would allow you to be on the phone with your daughter.
Okay, so there's no admin here on the weekends, so the weekends are out of the park. Excuse me, but administration, when are they here, Miss? What is it, 8 to 5? 8 to 5. So, and I would go, and the law library lady, she's telling me right now that I would go to either the warden secretary's office or the warden's office and make the call. They wouldn't have me, but it has to be Monday through Friday from between 8 a.m. and 5 p.m. But I know Mila likes to sleep in, so but I trust Mario wholeheartedly to make that decision. So y'all can waive that without me for sure. But it has to be from 8 a.m. to 5 p.m.
Okay, thank you. That's good to know. So, Mr. Garza, I expect you to come up with a date and time that you think is best for your daughter between 8 and 5, Monday through Friday, for a 20-minute phone call. If you want to put a backup day and time, say you do it Monday at 4:30. If she's not available then the alternative time would be, Tuesday at 8 o'clock, whatever it is. All right.
And I will always be available because I'm an inmate. So if they say, hey, you know what you got to do, come on, let's go. Then whether I'm in class or whether I'm asleep or whether I'm eating, whatever, hey, come on, you got to go. So I'm always available.
All right. All right, y'all. Thank you all. I will look for that order 2 weeks from tomorrow, which is August 7th. If you're not going to be able to get it to me, please give me an updated estimate of when you can get it to me. All right?
Okay.
Thank y'all. Y'all are excused.
And I just want to ask, can I get the paperwork? Can somebody send me all this? Like, is there a way that I can get all this?
So I will ask Ms. DeLong to send you a copy of the proposed order that she's drafting once she and Ms. Hobron come to agreement on what that should look like.
Yes, ma'am. Thank you.
All right. Thank you. Y'all are excused.
Thank you, guys. Okay, have a good day.